Hello, this is the Kelso Report's Supreme Court review for the October term 2011, and I'm your host, Clark Kelso. We cover the October term in 4 separate installments covering constitutional law, commercial and civil law, government law, and criminal law. In this 4th and final installment, we take a look at the major cases decided by the court in the field of criminal law. As usual, we had a substantial number of cases involving habeas corpus, and then a smaller number of cases raising federal issues of search and seizure, criminal procedure and evidence, and criminal sentencing. By and large, the court continues to be a law and order court, although we do see in Justice Kennedy a concern about protecting procedural rights, making sure a defendant had a full and fair opportunity to present his or her contentions, and a continuing interest in criminal law as it applies to minors. Well, the field of habeas corpus is, of course, dominated by the Anti-Terrorism and Effective Death Penalty Act, which imposes strict procedural and substantive limits on federal court habeas review of state court convictions. Principles of federalism, deference to state court proceedings, and finality of judgments are very clearly expressed in the Act, and in the Supreme Court's interpretation of the Act. But even though the deck is stacked against petitioners, our first 4 cases are good wins and show that the court is not insensitive to all habeas claims. In our first case, Wood versus Milliard, the Supreme Court held that where a state deliberately waives a limitations defense to a petition for a writ of habeas corpus, a federal court abuses its discretion by resurrecting the waived defense and dismissing the petition for lack of timeliness. In Wood, the state had twice informed the district court that it was not challenging the timeliness of the habeas petition. The district court proceeded to the merits and denied relief on the merits. Nevertheless, the 10th Circuit ordered briefing of the timeliness question and affirmed the denial of relief, but solely on the ground of lack of timeliness. The Supreme Court unanimously reversed, noting that the principle of party presentation generally precludes courts from raising issues sua sponte that have not been presented by the parties themselves. A narrow exception exists in the context of habeas cases where the court has recognized that structural and institutional concerns regarding comity for state court processes permits federal courts to raise inadvertently overlooked procedural bars, such as exhaustion and timeliness. But that narrow exception does not apply where the state has deliberately, and in this case twice deliberately, stated its intent to waive a timeliness defense. The petitioner also prevailed in our second case. Now, Arizona does not permit a convicted person alleging ineffective assistance of trial counsel to raise that claim on direct review. Instead, the claim can first be raised only in a state habeas proceeding. In Martinez v. Ryan, the petitioner's state habeas counsel failed to raise the ineffective assistance claim. After getting new counsel for the federal habeas proceedings, petitioners tried to raise an ineffective assistance claim both as to the trial and the state habeas proceeding, asserting a constitutional right to effective counsel in collateral proceedings. Justice Kennedy, for a 7-2 majority, sidestepped the constitutional issue and held simply that in the circumstances presented, the federal courts must excuse the procedural failure to bring the ineffective assistance claim in state court. The Supreme Court remanded to give the petitioner an opportunity to raise its ineffective assistance claim before the federal district court. In dissent, Justice Scalia takes the majority to task for achieving the same result as holding that there is a constitutional right to effective assistance of counsel by the expedient of holding that the federal courts, as an equitable matter, will excuse the procedural default of failing to raise the ineffective assistance claim in the first state collateral proceeding. I think all Justice Scalia really proves here is why Kennedy is reliably able to garner majority votes on the court, while Scalia has marginalized himself by spending all of his time in dissent. He hasn't figured out the value of compromise. Next, the law has been established since the Supreme Court's decision in 1963 in Brady v. Maryland that a state violates a defendant's right to due process if it withholds evidence that is favorable to the defense and material to the defendant's guilt or punishment. Well, this term in Smith v. Kane, the state's key eyewitness identified the defendant as the first gunman to come through the door as part of a home invasion robbery where 5 people were killed. His testimony was the only basis for implicating the defendant, since there was no physical evidence linking the defendant to the crime. But the key witness had given statements to the police right after the robbery indicating that he couldn't identify anyone because he couldn't see anyone's faces. He indicated 5 days later that he could not identify any of the perpetrators of the murder. Well, these statements were never turned over to the defense, and rather remarkably, the state courts in Louisiana did not think this non-disclosure constituted a Brady error. The state argued that the eyewitness also made other statements that he could identify the first gunman to enter the house, and that his statement 5 days after the crime was arguably made out of fear of retaliation. Well, the Supreme Court rejected all of these trial-level type arguments with an 8-1 decision granting the petition for habeas and vacating the conviction. Now, our fourth habeas case where the petitioner won, Missouri v. Fry. The defendant here was charged with driving with a revoked license for the 4th time, which exposed the defendant to a 4-year prison sentence. The prosecutor communicated to his counsel some alternative plea bargains, one of which gave the defendant the opportunity to plead guilty to a misdemeanor with only a 90-day jail term. Counsel failed to communicate the plea offer to his client, and the offer lapsed. The defendant ultimately pled guilty without a plea agreement and was sentenced to 3 years in prison. The defendant's habeas petition alleged ineffective assistance of counsel because of trial counsel's failure to communicate the plea offer. On post-conviction review in state court, the Missouri Court of Appeals held that there had indeed been ineffective assistance of counsel. The Supreme Court, in a close 5-4 decision with the opinion by Justice Kennedy, agreed that counsel's failure timely to communicate the favorable offer constituted ineffective assistance of counsel. In dissent again, Justice Scalia complained that the majority, quote, "today opens a whole new field of constitutionalized criminal procedure, plea bargaining law," close quote. Now, while that may be the case, given that an overwhelming percentage of criminal cases are resolved by plea bargain, it strikes me, and it obviously struck the majority, that having effective assistance of counsel during plea bargaining is a pretty important right as a practical matter. The Supreme Court remanded to the Missouri courts for a determination of whether counsel's failure was prejudicial. This will be a close question on remand because before the preliminary hearing in which the plea deal might have been acted on by the court, the defendant was arrested again for driving with a revoked license. And it's possible the prosecution would have withdrawn the deal, or the court may not have accepted it. Since these issues implicate state law and practice regarding plea offers, the court decided to give the Missouri courts the first crack at resolving the prejudice question. Now we start to have some losses for the petitioners. The Supreme Court's decision in Lafler v. Cooper dealt with an ineffective assistance of counsel claim in the context of another plea bargain. This time, the defendant rejected a favorable plea bargain on the advice of counsel, advice that turned out to be seriously mistaken. After the plea offer had been rejected, there was a jury trial at which the defendant was found guilty, and he received a much harsher sentence than that offered in the rejected plea bargain. As the case came to the Supreme Court, both parties agreed that the counsel's advice fell below the standard of adequate assistance of counsel guaranteed by the Sixth Amendment. So the only issue was whether there was prejudice, and if so, the remedy. On the issue of prejudice, the Supreme Court held that the petitioner would need to show that but for the ineffective advice, there is a reasonable probability that the plea offer would have been presented to the court, that the court would have accepted its terms, and that the conviction or sentence or both, under the offer's terms, would have been less severe than under the actual judgment and sentence imposed. If the petitioner shows that prejudice, and if the only difference between the plea offer and the conviction is the length of the sentence, the district court can order the defendant to be resentenced in accordance with the plea deal. However, if the plea involved something more complicated, such as a plea that involved dropping certain charges altogether, the proper remedy is to require the state to re-offer the plea deal, and then the state trial court can exercise its discretion in determining whether to vacate the convictions and resentence pursuant to the plea agreement, to vacate only some of the convictions and resentence respondent accordingly, or to leave the convictions and sentence from trial undisturbed. This all fleshes out the law now dealing with ineffective assistance of counsel at the plea bargain stage. Next, Wetzel versus Lambert. Now, as we all know, under the Anti-Terrorism and Effective Death Penalty Act, a federal court may not grant a writ of habeas corpus to a state prisoner unless the state court's adjudication of his claim resulted in a decision that was contrary to or involved an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States. That's the standard in Section 2254 D1 of Title 28. Thus, a habeas court must determine what arguments or theories supported the state court's decision, and then ask whether it is possible that fair-minded jurists could disagree with those arguments or theories, and disagree that those arguments are inconsistent with the holding in a prior Supreme Court decision. If a reasonable jurist could agree with the state court's decision, a federal court should not grant relief. Well, in Wetzel v. Lambert, the Third Circuit reversed a district court's denial of habeas because it found that one of two arguments in support of the state court's denial of relief was unreasonable. But the Third Circuit completely ignored the other independent ground for denying relief. And so the Supreme Court vacated the Third Circuit's judgment and remanded to that court so that it could undertake the reasonableness analysis on the alternative ground. At the very end of the opinion, the Supreme Court did its own mini-analysis, which suggests that the alternative ground was at least reasonable. But of course we'll have to see whether the Third Circuit picks up the hint. The Ninth Circuit actually got off to a pretty rocky start at the beginning of the Supreme Court's 2000 term by being reversed in a per curiam opinion involving a petition for writ of habeas corpus arising out of a California case where a grandmother was convicted of assaulting a child, resulting in death. The sole question was whether the 7-week-old victim, who was in the physical custody of the defendant, died as a result of sudden infant death syndrome, or whether she died as a result of shaken baby syndrome. There were 7 days of expert testimony on this question, with 3 experts from the prosecution and 2 experts from the defense. The jury found the defendant guilty, and the conviction was affirmed in the California Supreme Court, and the California Supreme Court denied review. It was affirmed by the California Court of Appeal, and the California Supreme Court denied review. A federal magistrate, and then the federal district court, rejected the petitioner's habeas petition, which asserted that there was insufficient evidence to support the conviction. The Ninth Circuit reversed and directed the district court to grant the petition. Well, under the strict standards of the Anti-Terrorism and Effective Death Penalty Act, federal courts have no power to afford relief unless the petitioner can show either that the state court's decision affirming the conviction was contrary to or involved an unreasonable application of clearly established federal law, or that it was based on an unreasonable determination of the facts in light of the state court record. Given the extensive expert testimony that was presented to the jury, the United States Supreme Court easily concluded that the Ninth Circuit had overstepped its bounds in reversing the district court's denial. It seemed clear to the Supreme Court majority that the Ninth Circuit simply came to a different conclusion about the cause of death and the grandmother's resulting culpability. but coming to a different conclusion is clearly not enough to warrant granting a request for habeas under the Anti-Terrorism and Effective Death Penalty Act. Now, Justice Ginsburg dissented in this case on the ground that review by the court never should have been granted, since the case did not involve any new principles of law. That is true, but the case is also not just about simple error correction. The case is really about the Supreme Court trying to discipline a rogue panel of the Ninth Circuit, sending an unmistakably strong signal that the Supreme Court is not going to tolerate the Ninth Circuit's passive-aggressive behavior in habeas. The last paragraph of the majority opinion notes that the Supreme Court had vacated and remanded this case twice before, calling the panel's attention to the necessity of deference to state courts in habeas cases. Each time, according to the majority, the panel persisted in its course, reinstating its judgment without seriously confronting the significance of the cases called to its attention. And so the struggle between the Ninth Circuit and the Supreme Court in habeas cases continues. It does make one wonder how many reversals it is going to take for the Ninth Circuit to get the picture that the Anti-Terrorism and Effective Death Penalty Act really has changed the rules in habeas cases. Well, it's not just the Ninth Circuit that needs some instruction. In Coleman v. Johnson, the Third Circuit Court of Appeals, reversing the district court, held that there was insufficient evidence to convict the defendant as an accomplice and co-conspirator of a murder. The Supreme Court reversed the Third Circuit unanimously in a per curiam opinion, concluding that the Third Circuit was not sufficiently deferential to the jury's role, given the doubly deferential nature of habeas review on an insufficiency of evidence claim. First, the state courts must defer to the jury's fact-finding role, and second, the federal courts must defer to state court decision-making in the habeas context. The Third Circuit's specific error was in adopting a standard for reviewing what constituted a reasonable inference by the jury that was too demanding. Excuse me. The Third Circuit required that a reasonable inference is one where the fact inferred is more likely than not to flow from the proved fact on which it is made to depend. And in order for a jury's inferences to be permissible, they must flow from facts and circumstances proven in the record that are of such volume and quality as to overcome the presumption of innocence. The Supreme Court rejected this state law-based standard, noting that in the habeas context, a federal standard applied. And the federal standard leaves juries with broader discretion in deciding what inferences to draw from the evidence presented at trial. Next, in Hardy v. Cross, the United States Supreme Court unanimously held in another per curiam opinion that the Seventh Circuit erroneously failed to give the state court's decision appropriate deference. Once again, the court reiterated that according to the Anti-Terrorism and Effective Death Penalty Act, it imposes a highly deferential standard for evaluating state court rulings. The substantive question in this case was whether the state had exercised good faith in trying to search for a witness to appear at a second criminal trial. It was clear that the witness, the victim of a sexual assault, was in hiding and trying to avoid testifying. The state trial court decided she was unavailable for the second trial and admitted her testimony from the first trial. Essentially, the Seventh Circuit identified 2 or 3 additional steps the state might have taken to locate the witness. The Supreme Court reversed, noting that the Sixth Amendment does not require the prosecution to exhaust every avenue of inquiry, no matter how unpromising, and the habeas standards do not permit a federal court to overturn a state court's decision on the question of unavailability merely because the federal court identifies additional steps that might have been taken. Well, our next habeas case in Bobby v. Dixon, the Supreme Court issued another per curiam opinion, this time to reverse a Sixth Circuit decision which had granted the petitioner's writ of habeas corpus. The Sixth Circuit cited 3 alleged errors by Ohio state courts, and the Supreme Court found that none of these constituted error, much less the sort of unmistakably clear error required by the Anti-Terrorism and Effective Death Penalty Act. In particular, the Sixth Circuit incorrectly held that when a person who is not in custody refuses to speak to a police without a lawyer being present, any subsequent custodial interrogation without a lawyer is forbidden. That is simply not the law, as the Supreme Court has never held that a person can invoke his Miranda rights anticipatorily before being in a custodial setting. Second, the Sixth Circuit held that police violated due process by urging the defendant to cut a deal before his accomplice did so. Well, there simply is no precedent to support that statement of law. Third, the Sixth Circuit incorrectly interpreted the Supreme Court's decision in Oregon versus Elstad, where the court held that police could not secure a non-Mirandized confession from a suspect and then Mirandize the suspect so he could simply repeat his confession, with the intention of diluting the impact of the Miranda warnings. Well, in this case, the defendant had confessed to a completely different crime, burglary, was subsequently given his Miranda warnings, and then voluntarily confessed to murder. The Sixth Circuit concluded that those circumstances violated Elstad, and the Supreme Court disagreed and reversed the Sixth Circuit. Next, in Green v. Fisher, a unanimous Supreme Court reaffirmed that in a federal habeas petition under the Anti-Terrorism and Effective Death Penalty Act, the clearly established federal law against which state court decisions are to be measured refers only to those Supreme Court cases decided prior to the last adjudication on the merits in state court. The defendant had been convicted in a Pennsylvania trial court of murder, robbery, and conspiracy, in part based upon the redacted confessions of 2 of the defendant's non-testifying co-defendants. The conviction was affirmed on direct appeal. Well, 3 months after that decision, the United States Supreme Court announced in Gray v. Maryland its holding that redaction of a confession does not necessarily cure the Confrontation Clause problem previously identified in Bruton v. United States by the introduction into evidence of an unredacted confession by a non-testifying co-defendant. Well, unfortunately for the defendant, or the petitioner in this term's habeas case, he did not secure any further merits review of his conviction in state court. He failed to file a petition for writ of cert from the U.S. Supreme Court, and he failed to raise the issue in his state habeas filings. So under the rules applicable to federal habeas, his petition had to be judged without the benefit of the decision in Gray v. Maryland, and the Supreme Court unanimously affirmed the lower court's decision to reject the petition for habeas relief. You might have assumed that a convict is always in custody for Miranda purposes. A convict is always in custody. But you would have assumed incorrectly, according to Justice Alito and 5 of his colleagues, including Justice Kagan, who held in Howes v. Fields that the habeas petitioner before the court was not in custody for Miranda purposes when he had been brought from his cell to a conference room to answer some questions, but was told at the beginning and reminded throughout the meeting that he was free to leave and could go back to his cell whenever he wanted. He was not physically restrained or threatened, was interviewed in a well-lit, average-sized conference room where the door was sometimes left open, and was offered food and water. According to the majority, a reasonable person in this environment would have felt free to terminate the interview and leave. The petitioner ultimately confessed to have engaged in sexual acts with a minor. In her partial dissent, Justice Ginsburg agrees that for habeas purposes the law is not clearly established in the petitioner's favor, but she would hold that were the case before the court on direct review, Miranda should preclude the state's introduction of the petitioner's confession against him. As she observes, it is hard to understand how being held in prison is anything other than being in custody. Next, the Anti-Terrorism and Effective Death Penalty Act has a very short 1-year statute of limitations for federal habeas claims, which runs from the date on which the judgment became final by the conclusion of direct review or the expiration of the time for seeking such review. In Gonzalez v. Thaler, the petitioner lost his direct appeal to the Texas Court of Appeals and then let his time for seeking further discretionary review expire as of August 11, 2006. However, the Texas Court of Appeals did not formally issue its mandate until September 26, 2006. Petitioner filed a state habeas petition which told the running of the federal period until it was rejected. Well, you know what is coming next. The petitioner filed his habeas petition a little more than 1 month late if you start the clock running as of August 11, but his petition would have been timely if the clock didn't start running until the mandate issued from the Texas Court of Appeals. The Supreme Court held by an 8-to-1 vote with only Scalia dissenting that the statutory language required the clock to start running when the time had expired for seeking further discretionary review, and that the timing of the filing of the Intermediate Appellate Court's mandate was completely irrelevant. For those of you who practice in this area, the court also held that a technically defective certificate of appealability is not a jurisdictional failure. Well, federal habeas cases do tend to drag on and on, particularly if the inmate is savvy to the sort of motions that can result in more hearings and more briefing. In Martel v. Clare, the district court had appointed counsel to assist in preparing the inmate's habeas petition way back in 1994. First petition was filed in 1994. 4 or 5 years later, counsel took a job at the Federal Public Defender's Office, and new counsel was appointed. A hearing was finally held on the habeas petition in August 2004, and the parties submitted post-hearing briefs in February 2005. The district court then indicated it did not wish to receive any further material on the petition. 1 month later, the inmate sent a letter to the court requesting new counsel on the ground that his counsel was seeking only to overturn his death sentence, not to prove his innocence. When the court inquired of counsel indicated he had met with his client, who now wished to keep his lawyer, so the court took no further action. But 6 weeks later, a second letter arrived asserting new grounds for seeking new counsel, to wit, that certain physical evidence at the crime scene had not been fully investigated, and his lawyers were not asserting that failure as a ground for habeas relief. 2 weeks later, the district court issued an exhaustive opinion denying the petition for habeas, and in a separate order denied the request for substitute counsel. There were 2 issues on appeal. The first question was to select the appropriate standard of review for considering requests for substitute counsel. The Ninth Circuit and a unanimous Supreme Court agreed that the appropriate standard is whether the interests of justice require substitution. The second question was whether the district court abused its discretion in failing to inquire further into the petitioner's second letter. The Ninth Circuit held the court abused its discretion, but on this issue, the Supreme Court unanimously reversed, holding that the second letter, which raised brand new claims of error, simply came too late in the process. As the Supreme Court explained, the district court was not required to appoint a new lawyer just so the petitioner could file a futile motion to reopen the habeas proceedings. In short, there must be an end to all litigation at some point. Well, that's it for the habeas cases. Now we have 2 search and seizure cases this term. In the first, the court takes a rather expansive view of the state's power to conduct invasive searches, while in the second case, the court takes a much more restrictive view of state power to use modern technology to conduct searches. The extent to which jailers can conduct invasive searches of even persons arrested for minor offenses was before the court in Florence v. Board of Chosen Freeholders of County of Burlington. The petitioner had been arrested during a traffic stop by a New Jersey state trooper who checked a statewide computer database and found a bench warrant issued for petitioner's arrest after he failed to appear at a hearing to enforce a fine. Part of the booking process at jail involved a mandatory shower with a delousing agent, being checked for scars, marks, tattoos, and contraband, having an officer examine his ears, nose, mouth, hair, scalp, fingers, hands, armpits, and other body openings, opening his mouth and lifting his tongue and lifting his genitals. He ultimately was released when it was discovered he actually had paid the fine. Well, he then sued under Section 1983, asserting that the search violated his 4th and 14th Amendment rights. Writing for a bare 5-justice majority, Justice Kennedy rejected the claim, holding that jailers have a reasonable responsibility to preserve the safety and order of their facilities, and that the searches did not go beyond what was necessary to serve those interests. The facts did not involve a body cavity search. Instead, as described by Justice Kennedy, in broad terms, the controversy concerns whether every detainee who will be admitted to the general population in a jail may be required to undergo a close visual inspection while undressed. Noting that jails admit some 13 million persons a year, the court reasoned that maintaining safety and order requires the expertise of correctional officials, who must have substantial discretion to devise reasonable solutions to the problems they face. As a general matter, a regulation impinging on an inmate's constitutional rights must be upheld if it is reasonably related to legitimate penological interests. Concurring separately, Justices Roberts and Alito emphasized that the holding was limited to situations where an arrestee was being committed to the general POP portion of the jail facility, since the interests in safety and order primarily related to management of the general population. The dissenters, led by Justice Breyer, argue that a full search such as that occurred in this case should be permitted only if the officers have a reasonable basis for thinking that a particular arrestee may present a danger to other detainees or members of the jail staff. But the majority found that standard essentially impractical and unworkable for correctional officers to administer. Now, the court's decision is clearly not a comfortable one even for the majority, and expressly reserved the question for another day of whether it is always reasonable, without regard to the offense or the reason for detention, to strip search an arrestee before the arrestee's detention has been reviewed by a judicial officer. So I have a feeling the court is not done with strip searches of persons arrested on minor offenses. Now, our second search and seizure case. In our hyper-connected world, privacy is rapidly becoming a thing of the past. But for our Supreme Court, advances in technology don't always come at the expense of our constitutional rights under the Fourth Amendment. Justice Scalia in particular has been wary about letting technology advances shrink reasonable expectations of privacy. And he does it again with the court's decision this term in United States v. Jones, where a unanimous court held that the government's attachment of a global positioning system device to a vehicle for purposes of tracking the vehicle's movements constitutes a search under the Fourth Amendment, and is therefore subject to the Fourth Amendment's warrant requirement. Consistent with his textualist philosophy, Scalia notes first that the Fourth Amendment expressly protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures. Second, he points out that a car constitutes an effect under this language. And third, that attaching a tracking device to an effect would have constituted a search within the meaning of the Fourth Amendment at the time it was adopted. While there were several concurring opinions and some differences in reasoning and emphasis, all of the justices concurred in the result. Well, we have 4 cases now dealing with criminal procedure and evidentiary questions. The government prevailed in 3 of the 4. First, for over 40 years, the Supreme Court has interpreted the Due Process Clause as requiring that eyewitness identifications in criminal cases that are the result of police-arranged suggestive circumstances must undergo special judicial review regarding reliability before being presented to a jury. This term, in Perry v. New Hampshire, the court was asked to extend the requirement of preliminary judicial review to an eyewitness identification that was not the result of police-arranged suggestive circumstances. Police had been called to an apartment complex because of a report of a man breaking into cars in the adjacent parking lot. The witness was being interviewed in her apartment by one police officer who asked what the person who was breaking into the automobiles looked like. Well, the witness pointed to the defendant, who was standing next to a police officer in the parking lot, and said, "He is the man." By a vote of 8-1, the Supreme Court rejected the argument that the court's due process cases required preliminary judicial review for reliability of this identification testimony before its admission to the jury. According to the court, those due process cases arose only in the context of police-arranged suggestive circumstances. And where the police did nothing to arrange any suggestive circumstances, the due process rule did not apply. Courts around the country have been struggling with evidentiary issues involving the admission of crime lab reports and the fairness of permitting an expert who was not involved in performing the underlying tests to testify about test results. The issue in Williams versus Illinois, which was an appeal from a rape conviction, was whether the Confrontation Clause was violated when an expert forensic witness for the prosecution testified that she matched a DNA profile produced by an outside laboratory, Cellmark, based on semen from the victim's vaginal swab, to a profile the state lab produced using a sample of petitioner's blood. And no one from the outside laboratory testified as to their processes and operations, and the expert had no knowledge of the outside lab's processes or operations. In a 4-1-4 split, the court held that the Confrontation Clause was not violated in this case. But because of the split in reasoning, we don't get a clean rationale in this case. The plurality opinion by Justice Alito first held that the statements referenced from the Cellmark report were not introduced to prove their truth, and were instead introduced as essentially hypothetical premises, which then formed the basis for the expert conclusion that there was a match. As the plurality noted, this type of expert testimony based on hypothetical facts has long been approved, and particularly in the context of a bench trial such as the criminal trial in this case. The court can be assured the limits of the expert's testimony will be recognized and respected. Justice Thomas provided the key fifth vote for the judgment. Thomas first rejected the plurality's conclusion that the statements were not introduced for their truth, but he nevertheless held that Cellmark's DNA report was not testimonial for Confrontation Clause purposes, since it was not made with the formality and solemnity required to trigger the protections of the Confrontation Clause. The contents of the report were not sworn to, they were not embodied in a formal declaration. Instead, it was simply an ordinary business report prepared for a client, and its introduction into evidence then for Justice Thomas did not implicate Confrontation Clause problems. This is an issue, I think, that in light of the 4-1-4 judgment is going to come back before the court. Well, the Double Jeopardy Clause protects against being tried twice for the same offense. The clause does not, however, bar a second trial if the first ended in a mistrial, generally. Before the court concluded deliberations in Bluford versus Arkansas, it reported that it was unanimous against guilt on charges of capital murder and first-degree murder, was deadlocked on manslaughter, and had not voted on negligent homicide. The court told the jury to continue to deliberate, and the jury did so, but still could not reach a verdict, and the court then declared a mistrial. All agree that the defendant may be retried on charges of manslaughter and negligent homicide. But the question was whether he could also be retried on charges of capital and first-degree murder. The Supreme Court held in a 6-3 decision that the Double Jeopardy Clause did not prevent retrial, since the jury never reached a final decision on capital and first-degree murder, and the court never entered a judgment on those charges. Under Arkansas law, the jury could either convict on one of the offenses or acquit on all. The trial court did not abuse its discretion by refusing to add another option, that of acquitting on some offenses but not on others. The dissent in the Supreme Court would have given effect to the announcement in mid-deliberations that the jury was unanimously against guilt on capital murder and first-degree murder, and would have required the court to take some action on what appeared to be a final determination of those charges. And now we turn to a few cases involving criminal procedure. Under the Supreme Court's decision a decade ago in Apprendi versus New Jersey, the Sixth Amendment reserves to juries the determination of any fact, other than the fact of a prior conviction, that increases a criminal defendant's maximum potential sentence. That principle has been applied in cases where the sentence was imprisonment or death. A majority of circuit courts had already extended Apprendi to sentencing facts relevant to the imposition of criminal fines, and the Supreme Court this term in Southern Union versus United States agreed that Apprendi applies to the imposition of criminal fines. And now we turn to cases involving criminal sentencing. In Setzer versus United States, the court held that the district court had authority to order that the federal sentence be consecutive to an anticipated state sentence that has not yet been imposed. The law here is pretty well established in favor of the court's holding. As the court noted, judges have long been understood to have discretion to select whether the sentences they impose will run concurrently or consecutively with respect to other sentences, either that they impose or that have been imposed in other proceedings, including state proceedings. So the only issue for the court here was whether that discretion extended to an anticipated state sentence. And quite a few of the circuit courts of appeal had already affirmed that such discretion existed. Finding no statutory bar, the Supreme Court agreed. As for the particular sentence in this case, a complication arose because the state court ordered its sentences to run concurrently, which created an apparent conflict with the federal sentence. Well, that conflict will be resolved in the first instance by the Federal Bureau of Prisons, which has the authority to determine how long the district court's sentence authorizes it to confine the defendant. If the defendant disagrees with the calculation performed by the Bureau, it can appeal that administratively and ultimately file a petition for a writ of habeas corpus. Next, we deal with an issue of retroactivity. Federal statutes impose mandatory minimum prison sentences upon those convicted of federal drug crimes. These statutes typically base the length of the minimum prison term upon the kind and amount of the drug involved. Until 2010, the relevant statute imposed upon an offender who dealt in powder cocaine the same sentence it imposed upon an offender who dealt in 1/100th that amount of crack cocaine. So it imposed, for example, the same 5-year minimum term upon an offender convicted of possessing with intent to distribute 500 grams of powder cocaine as upon an offender convicted of possessing with intent to distribute 5 grams of crack. This was widely criticized as unfair and racially discriminatory. In 2010, Congress enacted a new statute reducing the crack-to-powder cocaine disparity from 100-to-1 to 18-to-1. And the new statute took effect on August 3, 2010. The question before the Supreme Court in Dorsey versus United States was whether the Act's more lenient penalty provisions apply to offenders who committed a crack cocaine crime before August 3rd, but were not sentenced until after August 3rd. Well, this is a question of statutory interpretation, and the court held that the new, more lenient mandatory minimum provisions do apply to pre-act offenders who are sentenced after the effective date of the Act. Similar sort of issue arose under the Federal Sex Offender Registration and Notification Act, which requires convicted sex offenders to provide state government with information such as names and current addresses for state and federal sex offender registries, and to update that information as appropriate. Although the Act defined a sex offender to include offenders convicted prior to the Act's effective date, it also provided that the Attorney General shall have the authority to specify the applicability of the registration requirements to pre-Act offenders. In Reynolds v. United States, the defendant had argued to the District Court in the Third Circuit that vesting the power to determine the retroactive applicability of the Act to pre-Act offenders violated the non-delegation doctrine. The Third Circuit had avoided this constitutional issue by interpreting the Act as applying to pre-Act offenders irrespective of what the Attorney General did. Well, the Supreme Court reversed by a 7-2 vote, holding that the plain language of the Act gave the Attorney General the power to determine whether and how to apply the Registration Act's requirements to offenders convicted prior to enactment of the Act. The court remanded to the Third Circuit to consider the non-delegation argument. So the constitutional issue doesn't get resolved yet. We'll see what the Third Circuit does. The case may be coming back to the U.S. Supreme Court. Next, continuing the line of cases which have treated criminal punishments against minors as subject to more rigorous limitations under the Eighth Amendment, the Supreme Court held in Miller v. Alabama that a mandatory sentence of life without parole for minors under the age of 18 at the time of their crime violates the Eighth Amendment's prohibition on cruel and unusual punishments. The defendants in Miller were two 14-year-old offenders convicted of murder and sentenced to life imprisonment without the possibility of parole. In neither case did the sentencing authority have any discretion to impose a different punishment, even if a judge or jury would have thought that the defendant's youth and its attendant characteristics, along with the nature of the crime, made a lesser sentence, for example, life with the possibility of parole, more appropriate. The Supreme Court reasoned that such a mandatory scheme prevents those meting out punishment from considering a juvenile's lessened culpability and greater capacity for change. It also runs afoul of the Supreme Court's cases in the death penalty context, requiring individualized sentencing for defendants facing the most serious penalties. The message from all of these cases is that juveniles really are different, and that there are constitutional limits to how far a state can go in treating a juvenile as though he or she were an adult. And that's it for this year's criminal law cases in the Supreme Court's 2011 term. Hope you enjoyed the review. My name's Clark Kelso. Have a great day in the law.